for Fundamental Rights. My name is Başak Çelik, and I'm one of the co-directors of the Center for Fundamental Rights, together with Professor Catherine Costello. It's a great pleasure for me to welcome you all to this Fundamental Rights in Practice event series, in which we're going to be discussing corporate accountability for human rights abuses, opportunities, and challenges. This is part of an event series that we do at the Center for Fundamental Rights, where we really focus on human rights in practice. And one of our key aims is to bring scholars and practitioners together to discuss current challenges to the protection of human rights. So this is the third event in this series this year, and we're going to be having a fourth one, which will take place on the 22nd of April. Our final event on this series is going to focus on technology and human rights, and in particular, face recognition technologies and risks these pose to the protections of human rights. And we will be hosting the head of Amnesty International's Germany section, Markus Biko, amongst others. You can find information about all our events in our newly established Twitter site, which is at HertieCFR. And you will be able to receive any updates or register to these online events by getting some information from our Twitter website. So I'm very excited to open this event and also take part in it for two reasons. The first reason is that this is the first collaboration that we're undertaking with the Hertie School alumni, and specifically the Hertie School Alumni's London chapter. And one of our speakers is the alumni of the Hertie School. So if there are any alumni present at this event, I also would like to extend a very warm welcome to them. But this event is also an event that we're collaborating with the International Human Rights Law Interest Group of the European Society of International Law, which is one of the largest interest groups of the society. And I'm very pleased to have been one of its co-founders back in 2013. The second reason to be very excited about this event is because the field of business and human rights is a very constantly sort of developing field, and it's also a moving target because there are too many developments at too many different levels of practice in the field of business and human rights. So this has become a very important field of advocacy, practice, and scholarly work, I would say, for the past 20 years. And the sort of the creation of legal mechanisms, the efforts to create domestic and international accountability for multinational corporations for their involvement in human rights abuses has really seen a very wide range of diversity. So there are quite a lot of variations in how corporates are held accountable in different jurisdictions. And there has also been quite a lot of efforts on the international plane, both what we call soft law or guidelines, as well as efforts of creating hard law obligations through drafting of a treaty under the auspices of the United Nations. So this event really allows us then to zoom into practice and zoom into practice of business and human rights and corporate responsibility in different sites. And you will see that our speakers are excellently situated to discuss different practices across jurisdictions. So let me introduce our chair for this event. Today's event is going to be chaired by Alexandra Lily Cather, and she's a visiting fellow at the Center for Fundamental Rights in this academic year. She's an expert in international criminal justice, transitional justice, and human rights, with a focus on investigation, capacity building, policy-oriented research, as well as advocacy. Previously, she worked at the European Center for Constitutional and Human Rights, the International Law Program at the Chatham House, and at the British Institute for International and Comparative Law. As a researcher and a practitioner bridging the gap between practice and policy of human rights, I couldn't think of a better chair for this event. So welcome everyone, welcome to all our speakers, and I will leave the floor to our chair, Lily, at this moment.
Thank you very much, Başak, for this kind and excellent introduction. As the chair, I'm also very delighted to welcome you all to this Fundamental Rights in Practice event this evening. Before I introduce you to our truly stellar panel of speakers, I'm going to start with a bit of housekeeping. So in terms of run of show, I'm going to give a brief introduction of each speaker before you will hear from our fabulous panelists respectively about their work and experience on corporate accountability. There will be time for questions afterwards, and I kindly ask you to write them in the respective chat box on the side. And please feel free to write them down as they come to mind, also already during the presentations. Though please note that the event, with the exception of the question and answer session, will be or is already being recorded. And this means if you wish your name not to be popping up on the screen while it's being recorded, please only ask your question once the question and answer session has started, which I will announce after the presentation. Now, to make best use of this 1 hour we have, let's dive right into it. We're going to first hear from Professor Dr. Pierre Thielberger, who's Professor of German Public Law and Public International Law in Bochum, where he's also the Director of the Institute for International Law of Peace and Armed Conflict. He's the editor of several international law journals, co-convener of the Interest Group for International Human Rights Law at the European Society of International Law, and member in the advisory board of the German Institute for Human Rights. He has published on the issue of business and human rights, inter alia, in the Indiana Journal of Legal Studies and the journal Business and Human Rights. He was also observer at the United Nations Human Rights Council in the process for the elaboration on a new treaty on business and human rights. Thank you so much for being with us this evening. Now, may I kindly ask you to provide us with an overview of the topic of today's event? So, for example, what do you mean if we speak about corporate accountability, and what, from your point of view, are the opportunities and challenges that the field faces at this point in time? Pierre, the floor is yours.
Thank you. Do I have to start the presentation? No, you do that. Perfect. Thanks. Yeah, so first of all, thank you very much. Also, from my side, I feel very honored to be invited here. And so many people I know since so many years. Anna was my student once at the Hertie School. Başak is the reason why I got involved in the interest group of human rights at ECCHR. So I really feel like I'm giving a talk amongst friends, and all these 200 people who are also attending I don't see. So it's more like a talk with friends, which I really enjoy a lot. Thank you very much for this kind introduction. Yeah, we were only given 10 minutes time, and I will try to stick to this. Sorry, I have a cold a bit today. So I want to start off by emphasizing really how important the topic really is, right? And I want to bring to your attention, Başak was also already pointing to this, that the topic of corporate human rights abuses has become more and more important over the last decades. Başak said 20 years, maybe one could even say 30 years, I would say. And it's really been dramatic, right? And there's one incident that I want to point you to, if you're not familiar with the whole debate, which is always brought up as kind of the symbol of the dramatic situation. And that is this incident of the Rana Plaza building in 2013 in Bangladesh, where a big building collapsed, which held 5 factories in it, garment factories in it, with more than 1,000 people dying, 2,000 people being injured, most of them women in these factories, although it was previously known that there were problems with the building, and there was no legal grounds for, oops, the presentation went away. Can we put it back? I don't need it, strictly speaking, but so there was no legal claim for compensation for the families and the victims. So I think incidences like this make it really clear why this is such a horrible problem, really. So what is now the legal dilemma here? And are new rules needed? The answer is yes, they are. Why is the current system not functioning? International law doesn't help us much because corporations, as you might know, are not subjects of international law. And only very radical international lawyers want to change that. Most international lawyers say international law applies to states and international organizations, not to corporations. So End of story. And even if you think about special parts of international law, for instance, international criminal law, when we look to the International Criminal Court, there only individuals can be tried and not companies, right? So we don't really have the means in international law to address the issue. And then, of course, when we look to national law, which I think we will deal with a lot today in our session, there we have also a lot of problems, right? So we have different standards that apply in different legal orders. Of course, if you don't have the highest standard in terms of the standards that companies have to adhere to, that might even make you more attractive for investment. So a lot of people say what we actually see is a race to the bottom in terms of these standards if we don't have a mechanism that prevents that. Secondly, of course, when you think about big companies, international corporations, supply chains, subsidiary situations, then of course you have the problem that is well known probably to many of you, which is the corporate veil, which is essentially that you have this principle of a separate corporate personality, and to hold parent companies responsible for subsidiaries, for suppliers, is extremely difficult. And then the third problem, of course, is a very factual, practical problem, which I assume my two distinguished co-speakers will also address, is that often those who are most vulnerable and who are most in need of help, judicial help, are the ones least in the position to do so. For financial reasons, they might not have the knowledge to know what to do. And, it's quite it takes some courage, to take on, as individuals or a group, to take on a multinational company. And so that often prevents people seeking justice even where they could. So that's why the topic, I think, is very important. We go to the second slide. So given that the situation is dissatisfying, to say the least, we have initiatives at the international level that I will introduce to you first, and then we have initiatives at the national level. So at the international level, we have, as I said before, since 30 years probably the attempt to change things. Most initiatives failed. I'm going to spare you them. But I will point you to the two initiatives that are ongoing and that are very important. The one are the United Nations Guiding Principles on Business and Human Rights. I think it's fair to say they are the leading approach to the problem in international law. They relate to this gentleman that you see here, who is a professor at the Harvard Kennedy School, kind of the American pendant to the Hertie School. And this gentleman, John Ruggie, or John Ruggie to be precise, because he's of Austrian origin actually, has developed this framework, which you see on the right of the slide, which consists of 3 pillars, in which says states have a duty to protect individuals from third-party violations of human rights, and these third parties can, of course, be corporations. Then you have a responsibility of the corporations directly, and you have also the obligation to make access available both to the companies and to the states for victims. Yeah. So, and this is the leading approach in international law, the so-called United Nations Guiding Principles on Business and Human Rights. Why are they not a good solution? Well, in some ways they are. Their big strength is they are very much recognized. And that relates to the process by which they were drafted. They were drafted in a broad stakeholder process, which really over many years took into account all the opinions of civil society, of employers, employees, states. So they have broad support. That's the big strength of this approach. However, the biggest weakness becomes clear when you think about the second pillar, which is the one that is addressed to corporations directly. Here we are in the field of soft law. Right? So it's not a legally binding standard that is set here, in particular in the second pillar, and that is the one that speaks to companies directly. Now, because that is the case, that a lot of people say, but we need something that's more legally binding, we have a new ongoing initiative since 2014, if I'm not mistaken, which Lily mentioned. I'm also an observer to this process, which takes place at the Human Rights Council in Geneva, where some states, originally only a few, but now quite a few states, are trying to elaborate on a new treaty regime, which could create legally binding standards, which could oblige states to create certain standards in their domestic legal system. Yeah. that is open. We don't know how this will go. We have now 3 drafts over the last years. The 4th one is in elaboration, will be presented in summer. A lot of states are very critical of this, says it goes too far. But we have recently seen that more and more states have come on board with it. So it's definitely not a dead initiative. It's an initiative with hope, but we cannot say whether there will be such a treaty one day or not. Lastly, now turning to national initiatives, really, I should say that, yeah, I could say a lot about this. Maybe let me focus on the most important things. There are quite a few initiatives also on the national level to hold corporations responsible within their entire supply chain. In the Netherlands, you have it partially. In the UK, I assume Anna is going to talk about the Modern Slavery Act. I said the Netherlands, the Dutch child labor due diligence law. Switzerland has an initiative. So we see a few states that try to solve the problem somehow domestically in their legal order. And the most famous one is probably France, the so-called droit de vigilance, which has essentially said that corporations with more than 5,000 employees in France, or more than 1,000 in total, which are registered in France, have to establish and implement vigilance plans, essentially how they address the issue of human rights, how they make sure that in their business activity themselves or their partners do not abuse human rights. Yeah, and that's often seen as a positive example because it was a very early, prominent case, but it has also shortcomings. As I said before, it only applies to very big companies, which is obviously a big problem. Now, in the last 2 minutes of my presentation, I would like to turn to Germany, because that's a very interesting case, especially in these weeks. Especially really in these weeks, we could not be more topical. So we have something which is called the Nationale Aktionsplans, which we have since a few years, where we try to implement the United Nations guiding principles. How we try to give flesh to the soft law that I mentioned before from the international sphere. And the coalition has said, well, we'll have this national voluntary plan, kind of, and we'll assess how it goes. And they assessed it last summer. And how did it go? It didn't go well. Yeah, so very few companies actually did what they should have done voluntarily. Very few companies have reported, essentially. And so as they had promised in the coalition agreement between the Labour Party and the Conservatives, who are in government in Germany at the moment, they said, if that is the case, if it doesn't go well, we will bring legislation. And that's now what recently has happened. And that is now the draft of the so-called Lieferkettengesetz. Yeah, so very recently in February, just a few weeks ago, the 3 ministries that are in charge of this, which is economy, labor, and what's the 3rd one? Development, of course, have agreed on a draft proposal, which would oblige companies with more than 3,000 people, starting from 2023, and with more than 1,000 people from 2024, that they also have to implement these measures. Yeah, a lot of questions are open here. How does due diligence, exercise of due diligence relate to liability? If I adhere to due diligence as a company, is it sure that I will not be liable? Is it enough to oblige companies that have more than 1,000 employees? Many issues are open. We have a draft now. We will go forward with it. Apparently, the government is in favor of it. The 3 ministries have been very far apart in what they wanted. Now they've finally come together on this proposal, and it's not much there. It's just been released a few weeks ago. Final sentence, to end on a very positive note. What gives hope is that the European Union has joined the institutions being in favor of such initiatives. So while the European Union has been rather critical in the past, for instance, on the treaty initiative that I mentioned, that is now negotiated in Geneva, recently both the Council, the Council, the Commission, and the Parliament actually have all said they are in favor of European legislation on this matter. And we see different initiatives being negotiated also in the last weeks, essentially, in the Parliament, in the Commission. And so it is very likely that we will also see some European initiatives on this matter. So big problem, but the good news is on various levels, we are working on it. Thanks very much for your attention.
Wonderful, Pierre. Thank you so much for providing us with such a comprehensive overview to start with. And I think if we look at these initiatives, let them be on the domestic level or on the transnational EU level or even international level, we really see reflected what Başak was talking about at the beginning, that these initiatives or the results thereof, they wouldn't look like that if it wasn't for really effective and persistent ongoing collaboration between various actors from academia to practice to litigators, and also even campaigners. So it's really a discussion at the forefront of that field of law at the moment. Next up is Canel Labid. She's a French lawyer and legal advisor with the Berlin-based European Center for Constitutional and Human Rights, also known as ECCHR. And there she works, may I add, as a former colleague, on some of the most fascinating, I can say, frontline cases in the field of corporate accountability at the moment. She works on transnational litigation projects against business actors involved in international crimes and environmental cases. So, for example, the complaint against the French company Lafarge for complicity in crimes against humanity in Syria, the case against the German certifier TÜV Süd involved in a deadly dam break in Brazil, and the lawsuit in France against the wind park project violating indigenous rights. Canel, we are very much looking forward to hear more about your work. And in particular, I was wondering whether you could share more about how to prove intent of corporate actors aiding and abetting international crimes that I believe was touched upon both in Lafarge case and the complaint filed with respects to arms trade to Yemen in front of the International Criminal Court. And of course, we would also love to hear how you made use of the due diligence law in France to protect the human rights of an indigenous community in Mexico. Canel, the floor is yours.
Thank you, Darlene. Good evening, everyone. And also from my side, a very warm thank you. I feel honored to be part of such a timely discussion on opportunities and challenges for business and human rights. So yes, thank you for this. And perhaps briefly before I start with the presentation, a few words about ECCHR. We are a human rights organization. We're based in Berlin. And our work is to use legal means to counter power and accompany individuals that are affected by human rights violations to claim their rights and to demand justice. And in the BHR, the Business and Human Rights Department specifically, we build legal strategies together with those affected by human rights violations caused by corporate activity. And the objective of those actions is to address the structural causes of those violations and therefore hold business actors that are headquartered in Europe accountable for the human rights violations that they cause abroad, mostly in the global south. The main challenge that we are trying to counter with our work, I think, is the main challenge for the entire business and human rights field, as Professor Thielberger mentioned, is this assumption that in globalized economy, managers who are taking the decisions from the headquarters cannot know and do not know what is happening 1,000 kilometers away in their subsidiaries, even though they control them, even though all the benefits and profits are going back to the headquarters in Europe. And this is more than an assumption. It's an assumption that is also organized through law, because law makes it possible for parent companies in Europe to organize their irresponsibility towards the human rights impacts of their subsidiaries abroad. And so to exemplify this challenge and maybe speak about some opportunities to counter it, I wanted to take the Lafarge case in Syria and briefly go through it. So this case concerns a French cement company, which between 2012 and 2014 in Syria, as the conflict escalated, continued to operate its factory. And in order to do that, what it did is that it entered into financial agreements with several armed groups that were raging at its doorstep and in Syria generally. And those armed groups included ISIS. And the amount that was found in the judicial inquiry is at least 30 million euros that were paid to those armed groups. So what is very interesting in this case is that following a criminal complaint that was filed in 2016 by ECCHR and our partner Sherpa in France, as well as 11 former employees of Lafarge, it's both the executives of the subsidiary of Lafarge in Syria and the headquarters in France, who have been indicted for the financing of a terrorist enterprise and endangerment of people's lives. And it's also the legal entity as such, Lafarge in France, which has been indicted also on these charges. And the reasoning of the court is very interesting because it found the French actors, it indicted the French actors on these charges, despite the fact that the Syrian employees are employed directly by the Lafarge subsidiary in Syria, not by the parent company, and despite the fact that the payment to the armed groups were made from the subsidiary itself and not by the parent company. So in doing this, the court overcame what Professor Tilburger called the corporate veil, as it said that because Lafarge as a parent company has a control over its subsidiary, it must also be held accountable for the crimes that it may commit in Syria through its subsidiary. The second challenge that was already mentioned by Lily is proving intent of business actors as aiders and abettors of grave crimes, in particular in the context of armed conflict. And in the Lafarge case, again, Lafarge as a legal entity was charged in 2018 with aiding and abetting crimes against humanity committed by ISIS in Syria. But upon an appeal filed by the company against these charges, a Paris court cancelled it on the only ground that even though Lafarge was aware that it was facilitating the commission of crimes against humanity in Syria, it did not have the intent to see those crimes against humanity committed. So we have challenged what we consider is full interpretation of French law before the French Supreme Court, and a decision should be issued this year on this. And I want to briefly to go on the next. No, I don't have a slide on this, but I just wanted to briefly mention another opportunity with regards to corporate actors and armed conflicts and criminal accountability. That is that in 2019, in December, ECCHR, together with our partners in Yemen and Europe, we filed a communication to the Office of the Prosecutor at the International Criminal Court, in which we argue that European arms traders and governments who continue today to export weapons to Saudi Arabia and the UAE, the United Arab Emirates, weapons that are then used by those two countries to commit crimes against civilians in Yemen may amount to complicity in war crimes. And so the Office of the Prosecutor has announced that it will take a decision this year on whether or not it opens a criminal investigation or preliminary investigation on our communication. And I think that this would really be a strong signal to like development to follow, and a strong signal to counter the assumption that business, even in armed conflicts, is just a neutral activity which cannot become criminal to the extent of aiding and abetting international crimes. Maybe now to turn to civil litigation and to the loi de vigilance. As Professor Tilburger mentioned, there are a lot of developments right now in the field of human rights due diligence. But I think there is still, of course, it's the beginning. So we have an essential question now, which is how can we ensure that those human rights due diligence laws, such as the loi de vigilance or the German law, can really be a meaningful legal tool for communities that are impacted by corporate activities? How can they claim their rights effectively? How can they obtain compensation or the prevention of human rights violations? Here, an example of the case brought before French courts by the indigenous Mexican community Unión Hidalgo, together with our partner Prodesk in Mexico. In this case, the French energy giant EDF is planning a wind park project on the lands of Unión Hidalgo, who is, as I said, an indigenous community. And despite the fact that indigenous people have a right to be consulted in a free, prior and informed manner on projects that want to be developed on their land, it is very clear that since 2015, the community has not been adequately consulted on this project. And worst, the project has resulted in a strong polarization in the community, as well as in an escalation of risks, threats, and physical attacks against the human rights and land defenders of the community. So that is why Union Hidalgo filed a lawsuit against EDF in France. And in this lawsuit, based on the Loi de Vigilance, the community is asking EDF to comply with its duty of vigilance, to identify all the risks of human rights violations that result from its project or that they generate themselves through their subsidiary in Mexico, and to take all the measures that are necessary to mitigate those risks. And here I think, so the Loi de Vigilance is new, so we are testing how it can effectively be used by communities. And one test that we're making, and which is really a test for all, I think, the human rights due diligence laws in the future, is we have a threat of an irreparable harm for the community if this project is adopted in the current conditions. But what the Loi de Vigilance allows us to do formally is only to ask a judge in France to enjoin EDF to modify its plan de vigilance until it can effectively prevent the human rights violations. But we are doing this case in front of a classical civil court in France, so we have the usual delays applying, and those delays are quite long. So what we had to do is to file a request for interim relief, asking a judge on the basis of general civil procedural law in France, asking EDF to suspend its project until a decision on the merits of the case is taken. And this is, as I said, a very general mechanism that was not part of the Loi de Vigilance, and French judges have not used this mechanism until now in the context of complex transnational claims, in the context of, in particular, projects operated abroad. And the second test, and this will be my last point for the last minutes, is that in this particular project of EDF, the responsibility to implement a free, prior, and informed consent of the community lies with the state. The state has this obligation to protect this right, and the company is tolerating the fact that this right is not being respected, and it's contributing to these violations. But it's in many cases of corporate abuse, there is a very strong role of the state, and there is a distinct responsibility of the state, and sometimes a distinct failure of the state to protect the rights of the communities. And I think here we, with this case, will have the opportunity to specify concretely what is the human rights due diligence of a company when a state is failing to respect the rights of a community. I will leave it at here. I would just want to say a last sentence. I try to avoid talking about the pandemic, but I think that we need also in the BHR field see and anticipate the challenges that come with COVID-19, especially for the struggles of the communities that we are accompanying in our work, because those legal actions in Europe are just one tool that communities are using. They're part of social organization, they're part of the ability of trade unions to organize in their home country to strengthen their actions in Europe. And I think that before COVID, there was already a shrinking of the civic space of those communities. But now after COVID, I think their space is even more shrinked, and in particular digitally. And that's what we need to take into account as business and human rights practitioners in our strategies. Thank you very much.
Not only for your input, like situating all these cases on these fascinating landscapes you're exploring at the moment, but also sort of reminding us of the reality of today, and particularly the pandemic and what it means for the communities alongside which you're fighting. So thank you so much. I'd like to remind our dear audience that you can ask questions in the chat box, also around non-technical issues. We would like to hear from you. Even your thoughts, that doesn't have to be questions, or any input we can reflect on later on. And while I do that, I now turn to our last speaker, which is Anna Hoffman. And Anna actually is the initiator of this fascinating event. So thank you so much for the idea and also developing it with all of us through until today. So Anna graduated from the Hertie MPP program in 2015, and she's currently a barrister, litigation lawyer in the United Kingdom, where her work is focused on the intersection of business and human rights. She teaches advocacy at the Inns Court in London and has remained involved with the Hertie Moot Court team, having been a member of the very first team Hertie sent to the Jessup competition. Anna, it's great to have you with us today. I was wondering whether you can talk us through the jurisdictional challenges you are facing, especially in the United Kingdom, working on business and human rights cases and issues, as well as whether you can share some of the situations and reality of working on such cases.
Thank you, Lily, and thanks to everyone for being here and for making this happen, to my excellent co-speakers who are so concise and insightful. And I think it all merges really nicely together because you get quite different perspectives on different types of work that are being done in this space. And of course, it's really important what Kanel just mentioned, that there's also civic activism taking place, and that we should never lose sight of those people who are actually most affected by these, but might not be as visible or might not be as often on panels such as this one, but that's really important to keep in mind. And I know that this panel is quite litigation focused because that happens to be what Kanel and I are kind of very interested in. So it's been really good to have the kind of general overview at the beginning from Pierre. I think it's an excellent time also to talk about these specific issues. And I think I can link into this topic by talking a bit more at what Kanel was already hinting at, what happens when these human rights wrongs are committed abroad. What happens when we are, as we so often are, in a situation where this is in different countries, where we have the parent company, a different company in a different country to the subsidiary, and the wrong is not happening in the same country and in the same legal system. And that is really one of the challenges. And I know that we have a mixed audience probably here, some policy people, some legal people, some who are familiar with both worlds. And I hope all of you can take something away from this. I'll just try to talk about the basic principles a little bit, because I think that might be useful. And I hope I don't bore a lot of you while doing that. I was thinking I would focus on 3 cases, and you should ideally see them on the slide now, because these are really the seminal, well, the 2 first ones I've listed, they are very seminal cases, and the third one is one that is very large and ongoing, and I happen to be involved with. But if you are looking into this area and you're interested in business and human rights litigation and parent company litigation, then you probably won't get around Vedanta, for sure. That is the first case that I'm going to talk a little bit about. You have the full reference there. It makes for very interesting reading. It concerned toxic emissions from a copper mine in Zambia. And you had over 1,800 Zambian citizens as claimants. And then I want to spend some time on a very recent decision. It only came out this year. So this is very timely. And that's Okpabi, which also caused a lot of shockwaves and hope as well in the BHR, in the business and human rights community. It builds on Vedanta and elucidates many of the similar principles, but really cements the position that Vedanta established and is quite important. It concerns Shell, as so many of these cases do. That's something you will notice. There's a lot of Shell litigation around, not just in the UK, but also in the Netherlands, obviously, because that's where the headquarters is. But then the mother company, the parent company is in the UK. And the third case I wanted to talk about is Mariana. And that's another one of these dam cases from Brazil. A pattern you might see here is that we're seeing a lot of kind of energy and mining cases here. So natural resource extraction really is a focus area, as I can see it. And there's also some interesting work being done around protocols around, natural resource governance and these kind of things, which we don't have time to go into at the moment. Mariana is still ongoing. It failed at first instance and is currently being appealed. So it's very much an ongoing situation. It's the largest class action that was ever brought in the UK. The claimants are numbering over 200,000, which is part of the challenge, really, in this claim. And it's, as I said, a mining dam that collapsed and caused one of the worst environmental disasters in Brazil in recent times. And we will have to see where that is going. I've put a little bit of a quote, which is exactly what Canel already outlined, just to kind of tell you what this is all about. It's about trying to use the law in its various forms as a tool to ensure justice for rights holders. And that's kind of the project that I think a lot of people working on this have set themselves, and that is being tackled from various parts. Going to the first two cases, because they really belong together and it's useful to think about them together. It's notable that Vedanta is also fairly recent, and it was interesting because both of these cases happen within the already established tort law, and that's of course something that is important to think about. What is the legal basis for bringing a claim? And that could be, as you have seen, a criminal route, as Canel talked about, or it might be a new law that is being implemented and that has potential to have teeth. Some laws were already talked about, such as the Lieferkettengesetz, but also the Modern Slavery Act. Similar to concerns shared around some of these other initiatives, the Modern Slavery Act is also considered to be not very strong in terms of enforcement, not having much teeth. It's more of a you should report, and also only concerns large corporations. So similar limitations there. So it's been really interesting to look at kind of what possible routes there are within the existing system, and how that might interact with new initiatives and new laws that are being formulated at the moment. Vedanta was really groundbreaking, was much talked about and is still much talked about. And it was very interesting because it identified 4 routes to parent company liability. But before we look at those 4 routes, I should probably say something about jurisdiction. Now, the very basic idea here is that the first hurdle, as it were, is to establish whether a court, such as a court in the UK, or England and Wales, I should rather say, because Scotland is a different legal system, can even look at a case such as this, where the damage is in, say, Zambia or Nigeria. And for the policy people amongst us, I think a similar discourse that's quite helpful to bear in mind here is one of sovereignty. In essence, the jurisdictional battles are very similar to these discussions we have around national sovereignty, because the argument presented very often by these multinationals and by these parent companies is that no, this court in the Netherlands, in England, cannot be looking at this because these are within the jurisdiction and should only be looked at within the courts of, say, Nigeria or Zambia, and it's an undue interference with that system. And that is a real concern. And there are ways in which you can establish jurisdiction. And this is kind of the preliminary battle that needs to be had in these kind of cases where you want to sue the parent company in a different country. A link is needed. And for example, in the UK, there's a certain legal test you need to satisfy. And it's often put in terms of that there's a real issue and that the party that you want to sue is a necessary and proper party. And while looking at this test, and I won't go into that in too much detail, you can see it discussed in all of these cases if you decide to read one of them. It's quite important to look at how the necessary link with the parent company might be established. And that's where we get to these 4 routes identified in Vedanta. And the first one here, the parent company taking over management, is uncontroversial. That's well established. That's kind of direct control. But what is really interesting are kind of 2 and 3, especially where the parent company provides defective advice or is promulgating defective group-wide policies. Or 3, parent companies promulgating group-wide policies and taking active steps. And that is something that is indeed new, and that was discussed quite a lot, and that was picked up in Okabe as quite important, that group policies and formulation of group policies may be sufficient to bring the parent company within the picture. And that also led to some interesting side debates, whether that might have actually a counterproductive effect as to maybe then companies not wanting to promulgate such policies anymore and actually stepping back, this kind of hands-off approach. We might come back to that in the questions. I think probably on balance, given all the other pressures and initiatives, this is not a huge concern, but rather a step forward in establishing that parent company liability is not a special regime, and there's no presumption against it, and it's not so hard to establish, and you shouldn't have a mini trial. And linking to that idea of a mini trial, I just wanted to briefly talk about Mariana, because while Vedanta and Okabe have, I think, sent very hopeful signals and have led to ripples within the community of seeing, oh, maybe there will be more of this, maybe it will be a real floodgate situation. Mariana is a bit more of a cautionary tale. As I've said, it's a very large class action, and they were unsuccessful at first instance. And one of the big questions there that was a problem was the parallel proceedings in Brazil, and the fear of interfering with those, and the fear of potentially saying too quickly that another justice system is not effective enough, which is of course quite a tricky thing to say. And that's where kind of international politics enters the picture as well a little bit, or something that's often referred to as comity between the courts. So this is a bit of a cautionary tale. We'll see where it goes. But there's definitely much movement in this, and has given lawyers in the UK and elsewhere some hope. Very briefly, I'm conscious of time. Challenges. I think there's lots of challenges. We've already heard about lots of them. There's big conceptual ones. I think they can be overcome, but it's important to be aware of them. Always being aware of context, being aware of a potential tension between the duty to act in the best interest of your clients as a lawyer, so of the victims, but also maybe having the aim of achieving a landmark judgment and progressing things further. This need not be in conflict, but it's something to keep in mind, especially when settlement options are considered and settlement is available potentially. And balancing local accountability mechanisms with kind of international legal efforts. That's really important, I think, as well. And that's something that we get from Mariana as well. Time, always a huge concern. It takes a long time to bring these things, especially if you have a kind of pre-battle around jurisdiction. It can take a decade until you will see justice done. And there are practical hurdles, costs. Pierre already referred to that, and logistics around claimants. That's for sure something when you have 200,000 people in a class action, it was messy. But these can be overcome. And then last slide, ending on a very positive note, opportunities. Clearly there are opportunities, it seems trite to say, but huge opportunity to actually bring justice and redress to people affected by these wrongs. It's obviously a stick approach, carrot sticks. It needs both. It's something that is a stick very clearly, and it might have a signaling effect to other legal systems, and might also be developing the scope of international legal norms. There's some really interesting activity in the Canadian courts as well, where the Canadian Supreme Court recently gave a fairly strong judgment, saying that in a particular Canadian context, they don't think that corporations are automatically exempt from use Kogan's norms, so using international customary law as a basis. And there's lots of exciting things happening there. And it's just part of kind of contributing to the wider discourse and all of these efforts. And I'm very much looking forward to discussing these things with you in the time remaining. Thank you.
Thank you so much, Anna. And I already see many wonderful questions in the chat that we could probably fill the next hour with. So I'm going to go right into them. We have a